item 8, if there's nothing else on that. We have a request for reconsideration on CPC 251-15. I think this will be the first official appeal that we have heard as a body. So I'm just going to go over the rules real quickly that are published in our rules. Anyone who has filed a civilian complaint who is dissatisfied with the findings or recommendations approved by the POB can request consideration. In this case, Mr. Arasim was not happy, and he requested reconsideration under one of the bases where that's allowed. Those are that a policy was misapplied, that the findings or recommendations were arbitrary, capricious, or constituted an abuse of discretion, or that the findings, recommendations were not consistent with the record and evidence. In this case, it was granted, and we're going to be hearing that now. In terms of how this is going to go, the time allowed for request is going to go like this. We will hear 15 minutes from Mr. Arasim. There will be 5 minutes from any officers present, and I don't know that there are. 10 minutes for APD if you all wish to say anything. 10 minutes for the CPOA Executive Director, another 5 minutes for the complainant, and then we will make any decisions. New evidence may be accepted, although it is discretionary, it's sort of disfavored. New evidence is not favored for induction. Evidence which clarifies already in the record may be allowed. New evidence which is offered to contradict evidence in the record may only be allowed if such evidence appears convincing and is on an important matter. Board members, you can ask questions at any time, and the time limit stops during our questioning. So Ms. Contreras, you can jump on the thing and stop the timer so that we don't take away time. And then at the end, the board will have a discussion and make a decision. Any questions from anybody on how this is going to go? Okay, Mr. Arasim, can you start? We won't start your time but let's just take a second to go over what the complaint was and what the complaint was and what we ruled on. So I believe that the board ruled on this as part of our consent agenda, is that correct?
I believe that's true, yes.
Okay, so the original complaint had to do with an officer appearing out of uniform.
Well, I don't know, if you consider it not having its camera, I guess that would be out of uniform.
Okay. The SOP in question is 2-12E2B5, I think. Do you have that to read to us, Mr. Harness? We're not finding it here.
Chairman, I did not bring the SOPs with me. I did.
If you take a look at the information I gave you, Director Harness outlined that SOP in the findings letter, which I believe is Exhibit E.
Okay. So, Mr. Arasim, why don't you just go ahead and give us a brief sketch of what your complaint is, and then tell us why you're here and why we should reconsider it.
Okay. Before I do that, how do I get new evidence into the record? I don't really have new evidence. What I have is evidence that clarifies what's already in the record.
And what is that?
It's the actual pleadings from the court case that's involved here.
Okay.
The record was introduced into the record by either Director Harness or the investigator, I'm not sure which, looks like a screenshot of the court case, and it has all of the actions that went along and the dates and all that, and I have the actual pleadings. So basically what I'm doing is fleshing out that piece of evidence that's already in the record.
So how do the specific pleadings, which are going to go into a bunch of legal issues concerning that particular case. Court case, how does that help us determine whether or not, because what I asked you to do was start with what your complaint is about. And what your complaint is about is someone not wearing their camera, is that so?
Well, there was 2 SOPs involved.
Okay, so let's talk about that first.
Okay. The 2 SOPs involved, well, my original complaint concerned Officer G's violation of Department Camera Policy, which is General Order 139.3A, and then the Standard Operating Procedure, or SOP, 2012E2BI, and both of those were outlined in the findings letter. Let me find that.
And so, what's your complaint about? What
Well,
did the officer do that you're complaining about?
The SOP says that an officer is not allowed to go into district court in uniform. And there are 2 exemptions, one being that it's a preliminary hearing and one being that it's an emergency. So it's either or both. Okay? He can be exempted from going into court in uniform. And then, of course, the other one, the general order is that if you are in uniform, you must have a body camera, a lapel camera, whatever they're calling them nowadays.
Okay.
So those are the two issues. And the pleadings that I'm trying to get into evidence or onto the record will clarify the situation as far as it being a preliminary hearing. And I believe it'll clarify that for sure. And then, so that's why I want to get those pleadings into the record.
Okay, so what was the hearing?
The hearing was for a temporary restraining order, a TRO.
From who against
It
who?
was requested by a current police officer, current APD officer against the city and APD for, in an attempt to stop them from not giving him a promotion.
Okay, so the officer wanted to stop the promotional process for
Correct.
reconsideration, essentially?
Correct.
Okay, and that's the screen, is this Exhibit E?
Correct.
This is the
Yes.
screenshot from the
Yes.
court? Well,
Yes.
in the court's office.
And if you look at my preface that I gave you, the 1, 2, 3, 4, I think it's the 5th paragraph, I say in there, the exhibits marked G, H, I, and J is evidence that I asked to be placed in the record to add clarity to the evidence, specifically Exhibit E, which is what you just held up, that is already on the record, as allowed by your policies and procedures, where new evidence clarifies evidence already on the record may be allowed.
Okay, and how does the case detail on this case clarify? Just letting us know what kind of a case it is? That it's not
Well, yes, it does that, and it also will clarify some of the statements that were made by the only witness that was talked to in this case, and that would be Assistant City Attorney Samantha Halls.
Okay. Do either of you have an objection to allowing this in? Mr. Baker?
Chair Moore, I reviewed it, and I don't believe that it's a problem. Clarifications would be, if it's admitted for the purpose of clarifying what type of proceeding was there and detail related to the statement that was already underlying the investigation, I don't see a reason for the court to not accept that.
Okay, it's not being, it's not in for the truth of any particular matter, so we're just showing the scheduling. So that's fine, Mr. Arasim, it's in.
Good, thank you very much.
Keep going.
So, May I begin?
Please.
All right. Unfortunately, I wasn't able to make copies for all of you of all of these exhibits, just cost prohibitive, but I gave 2 copies to the chair and the vice chair and 1 for Director Harness. So it might be a little bit difficult for you to follow me along on this. My original complaint, which is Exhibit B, which is my original complaint, okay, as explained by Director Harness on page 1 of Exhibit A, which is the findings letter, concerned Officer G's violation of Department body camera policy, which is General Order 139-3A, and Standard Operating Procedures 2014A1A and 2014B2 that speak to an officer's attire while in district court that were evidently replaced in toto by SOP 2012E2BI. Both this general order and the SOP are outlined by Director Harness on page 2 of Exhibit A, which is once again the findings letter, which you guys should all have. Starting with the preponderance of the evidence concerning the camera policy, which requires uniformed officers while on duty to have such a recording device on their person, Exhibits B and C, and Exhibit C is the affidavit that I issued and put into the record from another witness that was not interviewed that backs up what I had to say. So Exhibits B and C, which are my original complaint and another witness's testimony, show on the record testimony from 2 witnesses, one being a trained investigator. Exhibit C from Mr. Sean Casaus. Mr. Casaus is a former police officer, so he's a trained observer. So my testimony on the record and his testimony on the record say that Officer G had no such recording device on his person. Additionally, even though Officer G was given every opportunity to do so, I have seen no evidence provided by him that he had recorded any encounters with the public as he is required to do so by APD policies, nor did he provide any witness to affirm his obviously false testimony that he was wearing a body camera on the day in question. Furthermore, there is no evidence disputing that Officer G was not in full uniform or that he was not on duty while at the district court. After considering this irrefutable evidence I have given you through my own investigation, I ask that you reverse the director's findings and find that Officer G did indeed violate APD General Order 139-3A. So that's the camera stuff. Now I want to go into the him being in uniform in court.
Hold on, Mr. Arasim. Dr. Brown?
Does the second one relate to the first one, the first policy? Do you want us to try to remember to do both of them at the same time, or would it be easier if we talk about one at a time?
Well, that's what I'm doing. That's what I'm doing. I first spoke about the camera policy.
No, but I mean for us to just
There's 2 issues, Dr. Brown. One is that he was in uniform in court. The other is that he didn't have a camera on, according to Mr. Arasim. Those are the 2 issues. What part are you confused about?
Which I think what you're saying is to deal with one issue completely and then deal with the second issue completely.
Well, you can't. I mean, they're mutually exclusive. So if the officer was in court under particular circumstances, they're not supposed to be in uniform, but if it's an emergency and they are in uniform, then they're supposed to be in their full uniform, which includes the body camera. Is that the gist of it? Is there a scene? Is that
yes, but the body camera policy has nothing to do with him being in court in uniform. The body camera policy has to do with him being in uniform on duty without a camera. That's the camera policy. He violated the camera policy by being in uniform and on duty and not having a camera.
but you're also complaining that he shouldn't have been in uniform to begin with, is that so?
That's a separate issue.
But it's all the same incidents.
It's a separate issue.
It may be a separate issue, but we're talking about a single incident, one particular
Yes.
day and time, right?
Yes.
Okay, then I want to handle the whole thing together. We can parse out the two SOPs separately, but I'm not going to go through the whole thing once for one thing and once for another thing, okay?
Okay.
I mean, you can talk about them separately, but
Well, then
it's,
you want me to just go on here? Okay, all
did
right.
that answer your question, Dr. Brown? No.
I've already gotten confused, but I'll keep listening.
Okay.
Okay, all right. Okay, so now I want to go on to the question as to his violation of the SOP, which is the being in uniform in court, okay? And under this SOP, Officer G is allowed 2 exemptions, one for preliminary hearings and/or one for emergency situations. The only testimony placed into the record that I was given via an IPR request. I asked for all of the records in this case via an IPR request. Affirming these exemptions comes from Assistant City Attorney Holtz, and oddly from Investigator McDermott and Director Harness due to their naive investigation. But before I go into this, I need to go into the background of the investigators and the director's conclusions by looking at some of the statements made by City Attorney Holtz in Exhibit F. And Exhibit F is a transcription of the telephonic interview that Investigator McDermott did with Assistant Attorney Holtz. So if you could, go to page 3, line 7, where Ms. Holtz testifies that the district court, of its own accord, scheduled the TRO hearing for December 14, 2015. Then she goes into a little more detail on this starting on page 5, line 24 through line 4 on page 6, wherein she states he, meaning the plaintiff, meaning the officer that was asking for the temporary restraining order, did not petition for an emergency hearing. The record shows these statements are false and a complete misrepresentation of the facts, but yet are strangely perpetuated by Investigator McDermott and Director Harness in their investigation. All petitions for a TRO hearing are considered an emergency by the courts. This is reflected by Ms. Holtz's own statements on page 6, line 19 through line 23 in Exhibit F that Investigator McDermott and Director Harness apparently chose to ignore. Exhibit E is fleshed out by Exhibit G and shows that the plaintiff did petition for a TRO on November 30th, 2015. Exhibit E is again fleshed out by Exhibits H and I, where they show the plaintiff did indeed petition for a TRO hearing on December 3rd, 2015, and the court quickly granted this hearing and notified the parties only one court day later on Monday, December 7th, 2015. On page 9, page 3, lines 9 and 10 of Exhibit F, Ms. Holtz testifies that her office was notified like a couple of days before the hearing. This is a false statement and a complete misrepresentation of the facts by Ms. Holtz, again ignored by the Investigator McDermott and Director Harness, as the record shows in Exhibit I, that her office was notified 7 days before the TRO hearing in district court. That's 350% more time than what she stated, what she testified to. Now I want to look at the record concerning this being a preliminary hearing that would grant Officer G an exemption to the SOP as outlined by Director Harness on page 2 of Exhibit A. And that goes back to the findings letter. Going back to Exhibit F on page 11, starting at line 16, Investigator McDermott asked Ms. Holtz if this hearing could be considered by any definition as being preliminary. This conversation continues to page 13, line 15. Ms. Holtz produces no factual evidence, but instead simply states that in her opinion, this is a preliminary hearing. Again, with the help of Director Harness, as outlined on page 2 of Exhibit A false narrative is created that completely misrepresents the facts. Anyone with experience, as I myself have, of going through a TRO hearing will tell you you have one shot at persuading the judge to grant or not to grant a TRO. And the record here bears this out in Exhibit J, wherein the court denied the TRO hearing 3 days after the hearing on December 17th, 2015. There was no secondary hearing for the parties to bring in additional evidence before the judge made her final decision to deny the plaintiff's legally submitted request for the TRO. The truth is, this was not a preliminary hearing in any sense of the word, and the preponderance of the evidence shows this. Officer G cannot be afforded the preliminary hearing exemption under this SOP because in this CPC, it simply does not apply. Now I'd like to talk about the emergency exemption under the SOP. Exhibit D shows Officer G was notified of the hearing 3 days in advance by Assistant City Attorney Melissa Kuntz. Ms. Kuntz is one of 3 co-counsels that represented the city as the defendant at the TRO hearing and was a named witness in this CPC, as can be seen on page 2 of Exhibit B, which is my original complaint, who was inexplicably not interviewed by Investigator McDermott or Director Harness. And as you can see in bold-faced type in the center of Exhibit D, it says, hearing will be at 3 p.m. We can meet and touch base beforehand. Now remember, Officer G is a trained...
Hold on a second, you lost me at that last one.
Okay.
So tell me where that is.
I'm sorry?
The quote you were just reading, I can't find it.
Oh, Exhibit B. Looks like this.
Okay.
The notification from Melissa Kuntz to Officer G on the Friday before the hearing was scheduled.
Okay, it looks to me like it's to Samantha Holtz. Where does it say that it's to Officer G?
Well, this is what Samantha Holtz put into the record and told the investigator was what was sent to Officer G.
Okay, because what I'm looking at here is a Outlook appointment.
Correct.
And it was sent by, sent on the 11th at 8:23 a.m., but it was only received by Ms. Holtz on the 11th at 8:53 a.m., so.
Well, Samantha Holtz testified on the record that Melissa Kuntz sent this to Officer G on the Friday before the hearing, which was 3 days before the hearing.
Okay. I guess what I would be looking for is his acceptance. Do we have that, or we just have hers?
You're going to have to talk to the investigator.
Okay. Okay, keep going, sorry.
But from the way I read the record, this was sent to Officer G.
Okay.
Okay, so, okay.
Okay.
All right. Now again, Officer G is a trained observer, but yet Attorney Holtz, again with the assistance of the director, as can be seen in Exhibit A on page 2, created a false narrative based on Attorney Holtz's hearsay that would have you believe this was somehow missed by Officer G. Okay, now, Ms. Ms. Holtz didn't have anything to do with this. This was sent by Ms. Kuntz to Officer G, okay? And she's just basically speculating in what she said to the investigator as to what this was all about.
Okay, well, it doesn't actually say that, and also, we're not in court. We don't have criminal or civil standards about hearsay. People can say whatever they want, and, you know, we hope
Sure.
the investigators track it down. But
Correct.
there's not there's nothing where we have to worry about a hearsay rule or a hearsay exception in this. It's
Okay,
just
well,
people just say whatever they say.
Well, if you look at Exhibit F, you will see that the investigator said, oh, so, you know, you weren't really involved with this, maybe I need to speak to Melissa Kuntz. And she got Melissa Kuntz's phone number, and she said that she would follow up and call Melissa Kuntz and interview her. And I was very surprised to not find any of those records, any interview of Melissa Kuntz, no, nothing.
Okay.
Okay, so as far as I'm concerned, it's hearsay. On page 2, Exhibit A of Officer G's as an aside statement proves he had intimate knowledge of this TRO hearing. And the statement made by the director that Officer G received no prior notice that he was going to court that day is completely false, as Exhibit D irrefutably proves Officer G was given notice 3 days prior to the TRO hearing taking place in district court. Critical thinking shows Exhibit D is nothing less than a simple reminder from Ms. Kuntz to Officer G about something he was already fully aware of, and that is clearly reinforced by his own as an aside statement on page 2 of Exhibit A, and in Exhibit F, wherein Ms. Holt speaks of extensive fact-finding communications with Officer G by her co-counsel, Ms. Kuntz, in the days leading up to the TRO hearing in district court that were once again ignored by the investigator and the director. Critical thinking will also bring you to the facts that no attorney planning on having a material witness testify in district court would leave it to the last minute to talk to this witness about the facts of the case or inform him as when he would be required to testify in court.
You're kidding, right?
Excuse me?
You're kidding, right? Attorneys call people at the last second all the time. All the time.
May I finish?
Please.
And no, I'm not kidding.
Okay.
It simply defies logic. Instead, Investigator McDermott and Director Harness ignore the true events, and would have you believe that not one, but 3 city attorneys dropped the ball with the only witness they had planned to bring forward to defend the city and Chief Eden. Not one attorney, 3. 3 attorneys didn't drop the ball with the only witness they planned to bring. I'm sorry, I just don't believe that. The preponderance of evidence clearly shows the truth that Officer G was fully informed of the TRO hearing well in advance of the SOP's emergency, and the SOP's emergency exemption cannot be afforded him in this CPC. I ask that you would reverse the director's findings and find that Officer G has no rights to the preliminary hearing or the emergency exemptions, and find that he did indeed violate department policy by wearing his uniforms in district court as is outlined in SOP 201 2E2BI.
Okay, thank you, sir. Are there any questions before we have the next?
Yes. I'd like to ask Director Harness.
Nope. If you have any questions of Mr. Arasim only.
Do you know what the chart of sanctions for violation of wearing your uniform in district court when you shouldn't requires?
I have no idea.
Okay,
So we will.
that's my question.
Okay, we will get that when we get there. Is there an officer that wanted to testify? There's 5 minutes for the officer.
May I make one more remark about that?
You may.
It's probably minor. Probably minor.
Okay, that the chart of sanctions is,
Right, yeah.
it's a minor offense.
Yeah.
Okay, thank you. Okay, APD has has 10 minutes if the department wishes to present anything. It's looking no-ish. Okay.
Chairman,
Okay. And so, Mr. Harness, the CPOA has 10 minutes.
Chair Moore, fellow board members, I believe in this case we conducted a thorough and fair investigation. This is an event where this is not recordable. You cannot record in court. You can't videotape a court proceeding. I believe the designation as put forth by City Attorney Holtz that this was a preliminary hearing because it was for a temporary restraining order. The next would be for a permanent restraining order, and that's why it is preliminary. I believe in this case, as far as the uniform violation, I stand by the exonerated finding. As it relates to the camera, the finding was not sustained. We don't believe that there was a preponderance of evidence to state whether or not the officer had his camera on that day. So that's why the finding was not sustained, and we stand by it.
Okay, so was Assistant City Attorney Coots interviewed, do you know?
Chair Moore, she was not.
And how come?
Based upon the interview of Ms. Holtz and based upon the severity or the nature of the allegations, we believe that we had enough evidence from Ms. Holtz to make a finding.
Other questions from the board?
Of Mr. Harden?
Yes.
Well, I guess I would ask the question of you now. If in fact the officer wore his uniform in the courtroom, contrary to courtroom policy, is there a specified sanction for such?
Chair Moore, board member Ray, this was a level 7, a verbal reprimand.
Thank you.
What happens next?
I have a question.
Yeah, Dr. Brown.
When you did your initial investigation, did these other 2 witnesses that were in the courtroom, were they, had you been told about them, or, well, I got confused at that part.
Chair Moore, board member Brown, the affidavit presented as a part of the appeal. This affidavit was presented afterward. This person was not on the witness list. Mr. Arasim was asked if he had any other information to provide when he was interviewed by Investigator McDermott, and at that time he said no. This affidavit was produced at a later date.
Okay, thank you.
Any other questions of the executive director?
No, I just have kind of a general comment. It's kind of confusing, and you don't have the script, if you will, before you to follow. And I know sometimes it's expensive, but it would really be helpful if we had something to really look at so we could go with you in case, you know, sentence by sentence.
I have a question. Whose responsibility is it to provide us, the board, with all the exhibits?
Chairman Moore, board member Cruz, we provided you with the information from the appeal. Mr. Arasim produced these documents this evening.
Okay.
I only had 3 copies.
Okay. It's very hard to.
Yeah, I'm sorry.
Very, very hard.
I'm sorry,
Only
yeah.
a couple individuals who can be along. It's very difficult.
Mr. Harris, have you requested that the CPOA office make copies and provide those to the board members?
Chairman Moore, he did not.
Okay. In the future, let's offer that to people, because it really isn't, unless there's hundreds of pages or something, it would be really cost prohibitive for the office. I think we do a disservice to people to not be able to follow along. He's going to get his 5 minutes. You'll ask a question at the end. Okay. Anyone else have any questions of the executive director?
One more question.
Uh-huh.
In this packet that you provided, is there a reason why the officer's name is censored?
Chair Moore,
We always
Board
do
Member
that.
Cruz, the officers' identities are always redacted as a part of the collective bargaining agreement.
Okay, understood. I just want to make sure that you know that I believe paragraph 3 in this affidavit has the name of the officer.
That Chair Moore, Board Member Cruz, that affidavit was provided by Mr. Arasim.
Okay, just letting that.
The citizens are not bound by the.
That, yes, I'm sorry, and that gentleman is no longer an APD officer, he's a citizen.
And, you know, Mr. Arasim is not bound by the contract. We ask everyone not to say the officer's names anyway. Okay, Mr. Arasim, you have 5 more minutes, sir.
Okay, I just want to speak to a couple of things that the director said. The first thing he said was that this was a thorough and fair investigation. I gave him 7 witnesses, they interviewed 1. I don't think that's thorough, and I don't believe that's fair. As to the hearing not being preliminary, the record clearly shows that there was no secondary hearing before the judge made a decision. TRO hearings are a one-shot deal. You go in there and you present your case, the opposing party presents their case, and the judge makes a decision. There is no secondary hearing on a TRO. What he's discussing is a permanent restraining order, which is a completely different animal. A temporary restraining order is exactly that. It's temporary, and it lasts, I believe, 5 to 10 days.
Yeah, and for me, and the board members are free to make their own opinion, I think a preliminary hearing is a preliminary hearing, and it has a specific legal definition, and that's what it is. So the real question before us is, was it an emergency? So to me, a preliminary hearing is a real thing, and this, you know, TRO is not a preliminary hearing. A preliminary hearing is a preliminary hearing. So
Right.
the question is, was an emergency that the officer was called over, you know, at the last minute?
I agree.
And so
I agree.
that's just me. You all are free to make your own.
Do you have anything else, Mr. Arasim?
Yes, I do.
Let him finish.
Yes, I do. As far as the affidavit, that's been placed into the record. That was already accepted by you guys, and that's in the record. And the preponderance of the evidence shows 2 witnesses that did not observe a body camera on Officer G's person, and I believe that the preponderance of the evidence shows that he did not have a camera on his person at the time, and he violated the general order. So there's that. What else? Oh, he made a comment about the officer who gave me the affidavit not being on the witness list. That's true. At the time when I was interviewed, I was unaware of this witness, and I later learned of him. So I wasn't able to give that information at the time when I was interviewed. But like I said, you guys accepted that affidavit into the record, and so you have 2 witnesses, myself and a trained observer, a former police officer, who both testified on the record that Officer G did not have a body camera on his person. So I believe he is in violation of the general order.
Is that the end of your comments?
Pardon me?
Is that the end of your comments?
Yes, ma'am, that's all I have to say.
Please, Mrs. Vine.
I'd like you to answer the question, who you believe was harmed, assuming that the officer was in the court, it wasn't a preliminary hearing, he was in uniform and didn't have a camera. Who was harmed by that? What was the negative outcome for?
That's not the question, ma'am. The question
It is the question to
question
me.
is, did he follow department policy or not?
So this is gotcha. That's what this is. We caught
You
you
can
doing
call it
something.
anything you like, but my reason for bringing this here is because the officer did not follow policy, and that is I believe that's one of the major things that this board is set up for.
So you're not claiming anybody was hurt by this?
No.
He was just out of uniform in your opinion?
Well, I don't know if anybody was hurt by it or not, because obviously the officer had to come from, go out into the public to and from the district court, and maybe he ran into somebody in public and had a
That's all
confrontation.
speculation. I'm asking you if any harm was done to you as a result of this officer doing what you say he did.
Yes, I believe so.
And what would that be?
That would be that this particular officer is a high-ranking officer, and he is showing bad leadership. And that could roll down the road to an officer that I might have an encounter with, where, again, we would get violations of policies all over the place. I mean, if a high-ranking officer can do it, why can't I? You know, as a field officer, as a patrol officer. So yes, I do believe it did hurt me, yes, I do believe so.
Madam Chair,
There's lots of,
Here's the problem I have. I know that there are lots of complaints that this agency gets that are about things like this, okay?
Mhm.
Somebody broke a rule,
Mhm.
a minor rule, a major rule, whatever it is, but no harm was done. We also have complaints, some of them from you, I believe, that have to do with cars not being registered, and we get one complaint after another. My concern is that as volunteers in this process, we're trying to get to the issues that we think are significant, and there has to be some kind of ranking for that. So for me, filing 20 complaints about cars that weren't registered instead of one, filing complaints in a gotcha kind of way is not the reason that this board was established.
Oh.
The reason this board was established was, and what this is keeping us from doing, is looking at officer-involved shootings, really digging in the dirt as far as things that we think significantly could affect the community. So I'm saying, for my dollar's worth, this is a gotcha kind of complaint. I'm not saying you can't make it all day long. All I'm saying is, I think it's a waste of everybody's time, because there's no harm done. And I don't see the harm. I haven't heard you tell me what the harm is. That's my 2 cents.
Well,
go ahead.
my view is that if you take care of the little issues, the big issues don't
Well,
occur.
you're certainly working on the little issues, sir.
Well, that's your opinion, I'm your opinion, and you're welcome to it. But like I said, if you take care of the little problems, the big problems take care of themselves. They don't happen, okay? And again, it's one of this board's jobs to make sure that police officers follow their own rules. And if they don't follow the little rules, and they don't follow this little rule, and they don't follow that little rule, and they don't follow this little rule, the next thing you know, they don't follow a big rule. Because they got away with not following a whole bunch of little rules, okay? So that's my answer to you, you know. You can take it or leave it, but
Dr. Ray has a
that's my
question.
Well, I'm going to defer to Johnny first.
Okay.
I was just going to say that I concur with everything that you had to say. I believe the same thing, absolutely. I couldn't have said it better myself. Thank you.
All right, Mr. Arasim, I think of this as a gotcha in a different way. You have 2 complaints and you want them looked at separately, but if you look at them together, logically they contradict one another. Because if the officer was found in uniform in the court, and that's a violation, then you're trying to double the violation by the fact that he wasn't in full uniform by having a camera on his person. Well, you know, that just, you know, you can't win. It's a catch-22. If he was in the courtroom with a uniform and shouldn't have had it, well, then he shouldn't have had a camera either. So
correct.
he didn't have the camera, so you can't complain about both things at the same time.
Not according to the standard operating procedures of the police department.
So did you sit in on this hearing?
Yes, ma'am.
Did the judge order the officer out of the courtroom?
No, ma'am.
So it's the district court's standing order that officers can only be in uniform under certain circumstances. And if the judge were upset, I think the judge would have either said something to the officer, like, what are you doing wearing that? Or would have sent the officer home to change. Did either of those two things happen?
Well, the record shows that the officer did not actually testify. He was there as a witness for the city to testify, and he ended up not testifying. So if he had ended up testifying and was sitting on the witness stand, I don't know what would have happened.
Right, if things were different, they would be the same.
Yeah,
so.
I don't know what would have happened. It's very possible that the judge would have, yeah.
Okay, but that's not how it happened.
No.
Okay. Any other questions for Mr. Arasim?
Just one.
Uh-huh.
Do you know this officer?
No, I don't believe I've ever.
Never met him,
I
never
don't
had an
believe-
encounter?
Well, we've nodded at each other and things like that, but I may have spoken to him somewhere along the line, but it was after this happened.
Mr. Baker, did you have something?
Chair, more members of the board, I just want a point of legal clarification on one matter with regard to the admission of the affidavit. Not so much that it's going to dictate an outcome here necessarily, but because I wanted to I want to clarify something legally under the rules, not so much because of how it may impact this, but because we want to set a precedent for how this will go in the future. The exhibits attached to the complaint were accepted solely for the purpose of clarifying what was already presented in the record below. And so to the extent they're now being offered to supplement and alter the record by adding another witness substantively to the testimony, that would be a different consideration for the board as to whether to accept it for that purpose. The analysis I was initially asked for was, are these fair game for clarification, and that's one thing, but I just heard argument that now there's two witnesses that support X, Y, and Z, and that would change the record that was available to the agency below at the time the decision was made.
Okay, thank you. Does the board have any discussion regarding this?
I just have a summary succinctly of what people understand. Sorry. We just have a succinct discussion of our statement of what we're to decide on this.
So,
We either find in favor of the appeal or we don't.
right, so we can, and correct me if I'm wrong, Mr. Baker, we can send this thing back to the agency for more investigation. We can reverse based on the information in front of us and say that the CPOA was wrong. Or we can retain our original findings that we did on the consent agenda and go with the agency's recommended findings. Am I leaving anything out? Yeah, Mr. Arasim.
It's perfectly fine with me if you take all the time you like. If you don't want to make a decision here tonight, I'm perfectly fine with you waiting until next month.
Okay. I think we'd like to, do it all in one shot while we remember what we're talking about, but thank you.
Well, I'm not sure if Mr. Cruz has what he needs in front of him or not. That's all I was going to say.
Are there any board members that would like to take a brief recess to review the materials? Because we can absolutely do that.
I really don't know how good that's going to do me. You spoke a lot, and I wasn't able to keep up with you. I'm sorry.
I can give you what I have. I have a complete set of these records. Would you like that?
Municipal territory, you can have a good
My personal feeling is that we've spent more than enough time on this. I'd rather we make a decision.
I concur.
You can make a motion.
Chairman,
Mr. Waits.
I make a motion that we retain the original findings as presented by CPOA.
Second.
We have a motion and a second to affirm our original decision to go with the findings of the CPOA in this matter. Discussion? Mr. Cruz?
Do we then write a letter to the plaintiff, Mr. Arasim, about this?
I'm sorry, Mr. Baker, what?
Chair Moore, it's, the procedure from here is spelled out in the policies and procedures, the copy of which I provided to you. So I can go back to it and specify what happens from here.
Okay, let's see. So the POB may affirm, modify, or change our original findings. The POB may make further recommendations to the chief regarding the findings or the discipline. In this case, that doesn't apply. Decision on appeal shall be made by the majority of the board members present. I don't see where it says whether there's a letter or anything that comes out of our decision, but, Mr. Arasim is here, I don't think he needs a letter, he knows what he said.
All right.
We asked the chief to give us letters. I think we should write one down, whatever we decide.
I think that's fine. We can do a letter that officially outlining whatever our decision is. Any other discussion? Okay. So we have a motion and a second to affirm our original decision in this case and go with the CPOA's original findings, Director Harness's original findings. All those in favor, please say yes.
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 Any opposed?
No.
Anyone wish to abstain? Okay. Those are our findings. Thank you, Mr. Arasim.
Thank you. May I ask one question?
You may.
Was there a decision made on whether that affidavit was put into the record or not?
The affidavit was in the record, not to give us any new information, but just to follow up on the information that we had already.
I understand.
Okay?
Thank you very much.
All right. Thank you. And Mr. Harness, I would suggest that we, on future appeals, offer that if folks have materials they'd like to present to the board where they're not able to make copies, that we could make some reasonable number of pages for them.
Yes, sir.
Okay? Thank you. 6:15, we have dinner coming.